A very good evening, my dear students and my dear friends, and welcome back to my YouTube channel. And thank you for the love and affection you have showed in my last three videos. I hope the videos are useful and beneficial for you. And New Year is coming. I hope you all are doing well, and I wish that in the coming New Year all your dreams and whatever you have in your mind will come in true. So in our last three videos we have discussed about CPC. Today we are going to discuss about a social evil. And the social evil is nothing but 498A IPC. This section is the only in one section in chapter 20A in IPC. Only one section. And the respective section has been inserted by 1983 Amendment Act. And the act basically dealing with cruelty. At the time, cruelty was so rampant in the society that the poor women are so aggrieved, so annoyed, so tortured that they don't even think to give their life. They committed even suicide. They thought that इस जिंदगी से तो बेहतर है कि हम मर जाएं, हम अपनी लाइफ खत्म कर दें. In our personal laws also, cruelty was never punishable act. In our personal laws, cruelty was never punishable act. In fact, women were treated so downtrodden that there was no question of giving them any right against cruelty by husband. And the husband think that they have the right to torture the woman who is his wife. There was the question of divorce at that time. डिवोर्स जैसे शब्द तो उस समय में होती ही नहीं थी. बहुत रेयर केसेस होता था कि लोग 498A से प्रताड़ित होके क्रुएल्टी से अपने लिए डिवोर्स सीख करते थे. Poor women were still to suffer their married life with cruelty, and they somehow managed to live in their matrimonial home. अब सबसे बड़ी समस्या क्या होती थी उस टाइम में? एक बार शादी हो गई तो वही आपका घर है. This was the basic concept and mindset in our mind. And for that mindset, number of women has committed suicide. Either they are burned, either they have taken their own life, or they are mentally suffered till they are living. But in our constitution, the very first fundamental right is right to equality. Article 14. Subjecting a wife to cruelty definitely infringes her basic fundamental right under Article 14 as well as Article 21, that is, her right to life and liberty. That is why the legislation in its wisdom decided to add one section making cruelty on women punishable. Since these are women empowering section, these are gender specific. Now what is gender specific? Gender specific means if you go through the literal interpretation of section 498A, you will find that whoever being the husband or the relative of the husband of a woman subject such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. It is gender specific section. Why? Because cruelty is not going through the husband. Cruelty is always over a poor woman who have left her home and with all trust and belief come to other home to live a happy married life. But sometimes it is very unfortunate that that poor woman has to suffer and going through all the torture, all the ignore, all the cruelty that has been done to her by their husband or their relatives. Not only the section not only bring the husband into the ambit of law, but also the relatives of the husband. Also the relative of the husband comes into the ambit of the law by this section. There are two women empowering section in IPC. First, 304B, that is dowry death, and 498A IPC, which is basically dealing with cruelty. Right? Now, when we are talking about the word husband or wife, the word husband and wife denotes legal husband, legally wedded lock, and legally wedded husband, legally wedded wife. Now, you think, as it is a social evil, if the husband get married with another woman and he tortured the second wife, whether the second wife doesn't have any right to protect herself or to prevent the cruelty which is going through on her. So in this basis, we have a beautiful judgment of the Supreme Court, Ruma Agarwal versus Anupam, 2004 Supreme Court, in which the Honorable Supreme Court held that the basic object of Section 498A is to protect a woman from cruelty by her husband, merely because he happened to be an illegal husband, that is, he got married after his legally wedded wife in life. In the lifetime of his legally wedded wife, he got married with a second wife. Illegal husband, maybe she happened to be a wife from a void marriage, cannot be enough to give the husband protection from 498A IPC. That means whether the married is a legally marriage or the wife is from wife is a second wife and she is a wife from a void marriage, it does not protect the husband or give the husband the right to do cruelty on her. Now, in other words, whether it is a valid marriage or an invalid marriage, in such case, the Supreme Court held, look at the legislation intention. The legislative intention is to protect every wife, legal or illegal. That means the motive of the legislature to crafted the section is to protect women from cruelty. Whether she is a legal wife or an illegal wife doesn't matter, doesn't give the right the husband or his relative to torture that particular woman. Because whether it is a void marriage or a valid marriage, legal marriage or an illegal marriage, still the woman is the woman. And if any kind of cruelty is going on her, that amounts to cruelty and does not protect the husband from the ambit of Section 498A IPC. This section was created to roping not only those validly married but also anyone who has undergone some form of marriage and thereby assume the position of a husband to live. Even in the issues of dowry, though dowry is linked with marriage and legal marriage under Domestic Dowry Prohibition Act, but then any person who enters into any illegal marriage also cannot take shelter behind the smooth screen. That means if the dowry is being demanded from the second wife, and the cruelty is going on her because of the illegal demand of dowry, the person cannot screen him behind a smooth screen that it is a void or illegal marriage. I would like to share one very beautiful judgment of Supreme Court where the Supreme Court, while giving the judgment, quoted in his first line, "Dowry, dowry, dowry." It is, the citation is State of Himachal Pradesh versus Nikuram, 1995 Supreme Court. In the very judgment, while quoting the judgment, the Supreme Court quoted the first word is dowry, dowry, dowry. Why? Because the dowry has been demanded in 3 occasions: before marriage, at the time of marriage, and just after the marriage. Cruelty can be on the basis of dowry, and it is the very basic reason. If you go through the social issues, you will find, and the cases which are going on in our courts, in our district courts, you will find that the basic reason for cruelty is dowry. Now coming to our topic again. First we go to the wording of section 498A IPC. First heading, what is the heading? Husband or relative of husband of a woman subjecting her to cruelty. Right? That means husband or relative of husband of a woman, all are coming under the ambit of the law. Now, I am reading the section. Whoever, being the husband or the relative of the husband of a woman, subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. Take. It is a cognizable offence, non-bailable offence. Now, coming to the very word husband, we know whoever being the husband. Whoever being the husband means whether the husband is from a legally wedded log or he get married to the second wife, he is a husband. Now coming to the very word or his relative. Or his relative means the person may be related to her, to the husband by blood, marriage or adoption. In this point, I would like to discuss one very interesting case which I think going on recently in everywhere. In every wedlock it is going on. John Indukla versus Kerala, 2005 Supreme Court, where the husband got married and the sister of the wife had an affair with the husband, and she also got married with her husband. I mean, what we called in the relationship is brother-in-law or जीजू. तो साली साहिबा ने अपने जीजू से प्यार करके शादी कर ली. Now she became the second wife, and the second wife is torturing the first wife. कि देख भाई अभी हमारी शादी हो गई है, अब तू निकल, तू अपने घर जा, अब मैं यहाँ पे रहने वाली हूँ. That is the fact of the case. Now in this case, what is held by the Supreme Court, Honorable Supreme Court? The second wife is not legal but related to her husband by marriage. शादी हुई तभी साली बनी. That means related by marriage. And that is why if she commits cruelty on first wife, she can be taken within the ambit of relative. ठीक. Relative of the husband for the purpose of section 498 IPC, 498A IPC would include friends or relatives of the first wife because they are related to the husband through marriage. The invalidity of a marriage can under no circumstances be granted as a license to the new wife to harass the earlier legally wedded wife. Okay? I hope we all are clear till now. Now we are coming to very important point, that what is cruelty? What is cruelty is to define, is the term is very difficult because cruelty is subjective. What may be cruelty for myself may not be cruelty for yourself, or what may be cruelty for yourself may not be cruelty for myself. It varies from person to person. To determine cruelty, the social background of the parties, social standing of the parties, economic condition of the parties, and so many other factors are to be taken into consideration to determine cruelty. Okay? Now you think, as an individual, we each and every individual are born and brought up in very different condition. And we are sensitive in our way. Our sensitivity varies from person to person. That is the reason why the Honorable Supreme Court had said that cruelty cannot be generalized. It is not possible to enumerate all types of acts which will constitute cruelty. There can be no straight-jacket formula for cruelty. You cannot lay down that this amount to cruelty, this amount to cruelty, this amount, this amount to cruelty. Why? Because it varies from person to person. The sensitivity we have as a person, the sensitivity differs from person to person. And as we are, as an individual, born and brought up in various very different conditions, might be what amounts to cruelty for me may not be amounts to cruelty for you. In this regard, I would like to discuss one important case, Muhammad Hussain versus Andhra Pradesh, 2002 Supreme Court, where the Supreme Court very clearly held that cruelty is always a question of fact. It depends on various factors such as sensitivity of a person, sensitivity of the victim, social background, economic background, education, etc. etc. So there are many variables. So before we decide this amounts to cruelty, so many factors have to be kept in mind. What amounts to cruelty is a question of fact. In other words, it depends to case. In one case, the Supreme Court held that putting malicious litigation against the wife also amounts to cruelty. एक कोई भाई साहब थे, हो सकते हैं शायद वो भाई साहब ने क्या किया कि अपनी वाइफ के ऊपर हजारों मुकदमे दर्ज करवा दिए, malicious litigation, and the Supreme Court held that it amounts to cruelty. I forgot the citation. Another very important case of Supreme Court West Bengal versus Urilal Jaiswal 1994 Supreme Court, where the Supreme Court, Honorable Supreme Court held that cruelty is always within the four walls of the house. You never expect neighbor and other people to produce evidences. You know, as a woman, it is the very inherent nature of woman to keep secrecy. What amounts to cruelty, what we are facing as a cruelty, we always hide it. We never discuss it with someone else. We are not going to make it like a social issue. या husband ने हमको मारा, husband ने हमको ये बोला. Always we kept secrecy. So you never expect that the evidence will came from the neighbor. बहुत टाइम ऐसे भी मैंने फैमिलीज देखे हैं, ऐसे भी मैंने घर देखे हैं, ऐसे भी केसेस देखे हैं जहाँ पे वाइफ को दिन रात पीटा जाता है, लेकिन वाइफ कभी अपनी जुबान नहीं खुलती बाहर जाके. वो अपने चोटों को, इवन यू ऑल्सो नो लाइक केसेस, वो उसके अगर चोट लगी होती है तो कोई पूछते हैं तो बोलता है अरे नहीं हम गिर गए थे, गिर के हमको चोट लग गया. शी नेवर यूज टू टेल द ट्रूथ. शी ऑलवेज kept the secrecy. If the victim is not even to remember the exact date, month, even it does not matter, evidence of cruelty most even found in secrecy. किस दिन हमको डांटा था, किस दिन हमको कुछ गंदा बात बोल दिया था, हमको गाली दे दिया था, हमको मारा गया, हमें याद नहीं रहता होगा. All the women, we never going to make it a diary and noted here that हाँ इस तारीख को इसने मेरे को ये गंदा बात बोला था, इस तारीख को इसने मुझे चाटा मारा था, इस तारीख को इसने मुझे घुसा मारा था. We are not going to keep writing in a diary and maintaining it. We wish to forget it. Why? Because he is our husband, and as the mindset आफ्टर मैरिज यही हमारा घर है, यही रहना है. So the women are based on the mindset, they kept the secrecy, and if the woman does not even remember the exact date or the month when the cruelty has going on her, it doesn't matter, because the evidence of cruelty is always found in secrecy. Now Justice Krishna Iyer, Honorable Justice Krishna Iyer, one of my idol, he quoted that wear and tear of marriage is not cruelty. छोटे मोटे झगड़े घर के ये हमेशा होते रहते हैं, इसको आप cruelty amount नहीं कर सकते. Cruelty is something much more bigger than this. And what Justice Krishna Iyer has quoted, sometimes in the stream there are pebbles, but pebbles cannot be taken as boulders. That means कोई नदी है, कोई stream है, तो उसमें छोटे छोटे पत्थर मिलेंगे. पत्थर का मतलब ये नहीं है कि वो बोल्डर है. छोटे मोटे wear and tear हर मैरिड लाइफ में चलता रहता है. That doesn't amount to cruelty. Cruelty is something bigger, something more, much more than this. I would like to discuss another judgment on this regard. S.H. Rao versus S. Raman, 1999 Supreme Court, where the Honorable Supreme Court held that merely because the husband had an affair does not amount to cruelty, unless the husband stopped giving maintenance to wife or started doing torturing cruelty on his wife. Mere affair does not amount to cruelty. Cruelty cannot be generalized. Cruelty differs from person to person, and cruelty is something much more than ordinary skirmishes. बिटवीन हस्बैंड एंड वाइफ, छोटे मोटे नोक झोंक अपने जिंदगी में चलते रहते हैं, उसको भी अगर आप क्रुएल्टी बोल के मुंह फुला के बैठ जाए तब तो हो चुका। छोटे मोटे झगड़े चलते रहते हैं। नाउ वी आर coming to a very important point, that the application for cruelty can be made by the wife or as per section 198 of CRPC. Section 198 of CRPC, how the provision has been given, who can file a petition for cruelty. Section 198 of CPC deals with that. CRPC deals with that. I'm sorry, I'm again repeating this. The application for cruelty can be given by a wife or as per the provision of section 198 of CRPC. That means section 498A read with 198 of CRPC. Now we are coming to explanation. For the purpose of this section, cruelty means any willful conduct. Mark the word willful. Willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental or physical, of the woman. Like, now willful conduct means, what is willful conduct? The conduct must be willful. Willful means which is of such a nature and the husband जानबूझकर, willful means जानबूझकर, and firstly the conduct must be willful and the willful conduct must be of such a nature which drives the woman to commit suicide or which affects her mental health or which drives the woman to endanger her life or limb. And coming to the second explanation, B, harassment of the woman where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security or is on account of failure by her or any person related to her to meet such demand. Now, explanation A of cruelty deals with a willful conduct of a person, of the husband or their relative, which the willful conduct is of such a nature that drives the woman to commit suicide or which affects her physical or mental health or the woman endangers her life, drives the woman to endangers her life. In explanation B, what has been written is deal with economic nature. That means harassment. Harassment means in Hindi I think it is pratarana, utpiran. Harassment of the woman in view to coercing her or any person related to her to meet any unlawful demand of property or valuable security. That is economic harassment. कि वाइफ को इतना टॉर्चर करो कि उसके माता पिता या उससे रिलेटेड कोई भी पर्सन हो वो जो इनके हस्बैंड या इनलॉज है, इनलॉज की अनलॉफुल डिमांड मीट करने में सहयोग करें, उनका अनलॉफुल डिमांड फुलफिल करें। जैसे आजकल ये होता है कि हर जगह में देखा जाता है कि बोथ वाइफ एंड हस्बैंड बोथ दे आर वर्किंग। तो अगर आपकी वाइफ वर्किंग वुमन है एंड शी इज़ ऑल्सो अर्निंग, उनसे ये कहना कि तुम अपनी सारी मंथली तनख्वाह मेरे पास रखोगी और मैं तुमको पैसा दूंगा, दैट अमाउंट्स टू क्रूएल्टी बिकॉज इट इज इकोनॉमिक हैरेसमेंट। The difference between the two explanation is firstly, explanation A is the willful conduct of the husband or the relative, and the conduct is of such a nature which drives the woman to commit suicide or to endanger her life, or which affects her physical or mental health. And explanation B is of economic harassment. Now, this is one aspect. What to do? This is law. But now, in our society, this crafting of legislation is being misused rampantly by the wife. As the section is gender specific and neither the IPC nor any other law deals with any kind of cruelty where the victim is the husband. Right? You never find the cruelty on a husband is considered upon. And the section 498A IPC, which is crafted by the legislature as an women empowerment section and to protect the woman from any kind of cruelty, but this section has been misused in all over the India. There are thousands of cases where this section has been misused. And बेचारा हस्बैंड कहाँ जाए? ऐसे कई केसेस मैंने भी देखे हैं जहाँ पे हस्बैंड को क्रूएल्टी किया जाता है, हस्बैंड को खाना पीना नहीं दिया जाता है, हस्बैंड को मारा पीटा जाता है. इवन हस्बैंड के इन लॉज फैमिली भी उसके ऊपर टॉर्चर कर देते हैं, बट स्टिल देयर इज नो लॉ रिगार्डिंग इट. एंड बेचारा हस्बैंड, as a lawyer, I think you also know about this, that there are thousands of cases which are just lost due to harassment, only to harass the husband or their relatives. I would like to discuss one very important and landmark case in this regard, that is Arnesh Kumar versus State of Bihar and other. This is very landmark case. Once a time is there that if a woman file any complaint of cruelty under 498 IPC, the police immediately arrest the husband and their family members. In this very case, the Supreme Court has provided some guidelines that as there is rampant misuse of the particular section, the immediate arrest should not be made. There are some guidelines regarding this. So if any case come to you, or if any complaint has been or FIR has been lodged against you of 498 IPC, not to worry. There is no provision of immediate arrest as per the guidelines given in the very case Arnesh Kumar versus State of Bihar. Then another case in this regard is Rajesh Sharma and other versus State of Uttar Pradesh and another, where it is discussed that 498A, misuse of 498A, there is rampant misuse of 498A. And not only these two cases, There are hundreds of cases like this where 498 IPC has been misused by the wife only to harass the husband and his family members. So if any false case has been registered, not to worry, as there is no immediate arrest as per the guidelines given by the Supreme Court in Arnesh Kumar versus State of Bihar and another, and you can easily prove if it is a false case and the misuse of section 498 IPC. Sometimes the cruelty is a social evil, even the cruelty is still a social evil, and to stop the social evil, the section has been crafted, but misuse of the section is very dangerous. Thank you. This much for today. In our next session, we will discuss about in another social aspects.